In the Eye of the Law, How White Supremacy Enlisted the American Legal System by Louis Menand. This is a quote. White nationalist, white supremacist, Western civilization, how did that language become offensive? Close quote. The Iowa Congressman Steve King inquired of a Times reporter last month. White nationalist, white supremacist, Western civilization, how did that language become offensive? After the remark blew up, King explained that, quote, by that language, he was referring to Western civilization. He also said that he condemned white nationalism and white supremacy as an, quote, evil and bigoted ideology, which saw in its ultimate expression the systematic murder of 6 million innocent Jewish lives, close quote. It's unclear whether King thinks of Jews as non-white. However, to answer the congressman's original question, only after a long struggle. How did that language become offensive, is your question? And Menand answers, only after a long struggle. 17 states had laws banning interracial marriage, which is pretty much the heart of the doctrine of white supremacy, until 1967, when the Supreme Court declared them unconstitutional. From the Compromise of 1877, which ended Reconstruction, to the Civil Rights Act of 1964 and the Voting Rights Act of 1965, American race relations were largely shaped by states that had seceded from the Union in 1861. And the elected leaders of those states almost all spoke the language of white supremacy. They did not use dog whistles. Quote, white supremacy, unquote, was the motto of the Alabama Democratic Party until 1966. Mississippi did not ratify the 13th Amendment, which outlawed slavery, until 1995. How did this happen? How did white people in a part of the country that was virtually destroyed by war contrive to take political control of their states, install manifestly undemocratic regimes in them, maintain those regimes for nearly a century, and effectively block the national government from addressing racial inequality everywhere else? Part of the answer is that those people had a lot of help. Institutions constitutionally empowered to intervene twisted themselves every which way to explain why, in this matter, intervention was not part of the job description. One such institution was the Supreme Court of the United States. The case of Martha Lum is typical. She was the daughter of Jiu Gong Lum, who came to the United States from China in 1904. After being smuggled across the Canadian border by human traffickers, he made his way to the Mississippi Delta, where a relative ran a grocery store. In 1913, he married another Chinese immigrant, and they opened their own store. They had 3 children and gave them American names. In 1923, the family moved to Rosedale, Mississippi, and Martha, then 8 years old, entered the local public school. According to Adrienne Berard, who tells the Lum's story in Water Tossing Boulders, a book that came out in 2016, nothing seemed amiss for the first year. But when Martha returned to school after the summer, the principal relayed the news that the school board had ordered her to be expelled. Public schools in Mississippi had been racially segregated by law since 1890, and her school educated only whites. The board had decided that Martha was not white, and consequently, she could not study there. The Lums engaged a lawyer who managed to get a writ of mandamus, an order that a legal duty be carried out, served on the school board. The board, which must have been very surprised, contested the writ, and the case went to the Supreme Court of Mississippi, which ruled that the board had the right to expel Martha Lum on racial grounds. That part was not so surprising. He described it as a typical case. The court acknowledged that there was no statutory definition of the colored race in Mississippi, but it argued that the term should be construed in the broadest sense, and cited a case it had decided 8 years earlier, upholding the right of a school board to expel from an all-white school 2 children whose great aunts were rumored to have married non-whites. That decision, the court said, showed that the term colored was not restricted to, quote, persons having Negro blood in their veins, close quote, apparently since the children involved were in fact white. Martha Lum did not have, quote, Negro blood either, but she was not white. She could attend a colored school. Mississippi's separate schools law, the court explained, was enacted, quote, to prevent race amalgamation, close quote. Then why place an Asian American child in a school with African American children? Because, according to the court, the law was intended to serve, quote, the broad dominant purpose of preserving the purity and integrity of the white race, close quote. The Lums appealed to the U.S. Supreme Court. At issue was the 14th Amendment, which had been ratified in 1868. The first clause of that amendment is the most radically democratic clause in the entire Constitution, much of which was designed to limit what the founders considered the dangers of too much democracy. It decrees that any person born in the United States is a citizen, and that states may not abridge the privileges or immunities of citizens, nor deprive them of life, liberty, or property without due process of law, nor deny them the equal protection of the laws. The United States has two founding documents, the Constitution, which is a legal rule book, and the Declaration of Independence, a manifesto with no force of law. The 14th Amendment constitutionalized the Declaration. Great line. I'll repeat that. The United States has two founding documents, the Constitution, which is a legal rule book, and the Declaration of Independence, a manifesto with no force of law. The 14th Amendment constitutionalized the Declaration of Independence. That's great. The U.S. Supreme Court decision on the case Lum v. Rice was handed down in 1927, 3 years after Congress passed the Johnson-Reed Immigration Act, which barred all Asians from entering the United States. Yeah. Was Martha Lum a citizen? The Supreme Court said she was. Was she being denied the equal protection of the laws? The court said that she was not, and cited a series of precedents in which courts had upheld the constitutionality of school segregation. It was true, the court conceded, that most of those cases had involved African American children, but it couldn't see that, quote, pupils of the yellow races, close quote, were any different, and the decision to expel such pupils was, it held, quote, within the discretion of the state in regulating its public schools, and does not conflict with the 14th Amendment, close quote. Even though the Mississippi court had stated that the purpose of the school segregation law was to preserve, quote, the purity and integrity of the white race, close quote, it was not a denial of equal protection to non-whites. The Lums, of course, knew from firsthand observation what it meant to be classified as colored in Mississippi. And they did what a lot of African-American Mississippians were also doing. They left the state. The decision in Lum v. Rice was unanimous. The opinion of the court was delivered by the Chief Justice, William Howard Taft, a former president of the United States. Among the justices who heard the case were Oliver Wendell Holmes Jr. and Louis Brandeis. One of the precedents the court quoted prominently in support of its decision was a case it had decided 31 years earlier, Plessy v. Ferguson. After Dred Scott, Plessy is probably the most notorious decision involving race in the history of the United States Supreme Court. It is the case identified with the principle of, quote, separate but equal, close quote. The theory that segregation is not, per se, discrimination. Plessy is the decision the Supreme Court had to overturn in Brown v. Board of Education in 1954 to declare that school segregation violated the Equal Protection Clause of the 14th Amendment. From our perspective, therefore, Plessy looks huge. So it's revealing that, as the journalist Steve Luxenberg tells it, in, quote, Separate, the story of Plessy versus Ferguson and America's journey from slavery to segregation, little note was taken of the decision at the time. Even when principal figures in the case died years later, their obituaries made no mention of it. It's revealing because it suggests that Plessy should never have been brought in the first place. The decision did not create a new justification for racial segregation. It locked an old one into place. Plessy was a test case. It challenged a law that Louisiana passed in 1890, the Separate Car Act, requiring railroads to maintain separate cars for white and colored riders, in order, according to the act, quote, to promote the comfort of passengers, close quote. The penalty for breaking the law was a fine or a short prison sentence. Transportation had been segregated in parts of the country, both north and south, since long before the Civil War, and many cases had been brought by passengers complaining of discrimination, with mixed success. But in those cases, segregation was a matter of company policy. In the Louisiana case, the constitutionality of a state law was at issue. When the South began instituting Jim Crow, after the end of Reconstruction, laws mandating separate cars on trains appeared across the region. One of the first was passed in Florida in 1887, followed by Mississippi in 1888, and Texas in 1889. When Louisiana passed its separate car law, a New Orleans lawyer and newspaper editor named Louis Martinet, his mother was born a slave, his father a Belgian, bought her freedom. He formed the Citizens Committee to test the constitutionality of the separate car law and set about building a case. First, Martinet approached the Louisville and Nashville Railroad, which agreed to act as a silent partner. It did not do so out of altruism. From a business point of view, segregation represented a cost, the cost of providing separate facilities for black customers. It would have been cheaper for the railroads if the state had mandated integration instead. Then Martinet recruited a plaintiff, Daniel Dedunes, a young mixed-race musician whose father was on the committee. On February 24, 1892, Dedunes boarded a train in New Orleans with a ticket for Mobile, Alabama, and sat in a car reserved for whites. By the way, I don't know if I'm pronouncing his name. Daniel Desdunes. Dedunes. He sat in a car reserved for whites. He was duly arrested and charged, his case set to be heard by the criminal court judge in New Orleans, John Ferguson. All had gone as planned, but then, in another case, the Louisiana Supreme Court ruled that the Separate Car Act did not apply to interstate passengers. Because Dedunes had been going to another state, he could not be required to use a separate car, and the prosecution dropped the case. So he was going to another state, so it's not an issue. So the attempted politicization of it was actually stopped by that. The interstate travel issue was a persistent wrinkle in the Jim Crow era, and it inspired some impressive judicial contortions. In 1878, for example, the U.S. Supreme Court struck down a Reconstruction-era Louisiana statute requiring integrated facilities on steamboats. Under the Constitution, only Congress has the power to regulate interstate commerce. Because riverboats stopped in many states, the court said they could not be bound by the regulations of one state. You might assume that a state law requiring segregated facilities on interstate carriers would be subject to the same prohibition. In 1890, however, the Supreme Court held otherwise. It declared that an interstate train was subject to a Mississippi law requiring separate cars for colored and white passengers. By the way, colored is in quotes throughout, just so I want to make sure you don't think I'm saying colored, and white passengers for as long as the train was in Mississippi. The court somehow parsed its way around its own earlier decision. But now, because of the Louisiana Supreme Court's ruling, Martinet needed another volunteer scofflaw. Fortunately, he had one at hand, Homer Plessy. Like Dedunes, Plessy was light-skinned, quote, fair-skinned enough to cause confusion, close quote, as Luxembourg puts it, suggesting that Plessy might have been accustomed to passing as many nominally colored people in New Orleans did. He was 29 years old, married, and in the shoemaking business. Like Desdunas, he followed the script. On June 7, 1892, he boarded a train, one traveling only within the state of Louisiana, and sat in the car for white passengers. When the conductor asked if Plessy was colored, he said yes, and was removed from the train and booked. Train conductors were in a ridiculous position. Even if the law required trains to have separate cars, riders could still sue the conductor for misclassifying them. Plessy came before the same Judge Ferguson, who ruled that since there had been no claim that the cars for white and black passengers were not equal, there was no constitutional issue. The Louisiana Supreme Court agreed, adding that if the Separate Cars Act were declared unconstitutional, many other state laws on separate schools, intermarriage, and so forth would be affected. The U.S. Supreme Court finally heard the case 4 years later, and on May 18, 1896, it issued its opinion. As Luxembourg points out, the concept separate but equal, quote, separate but equal, the phrase the court used in Plessy versus Ferguson, was actually equal but separate, was hardly a novelty. It had been a customary way to throw out complaints about segregation since before the Civil War. In Plessy, the court added a gloss that became almost as famous as the phrase itself. Quote, "We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority." Quote. It said, quote, "If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it," close quote. As Charles Black, a Yale law professor, wrote of these sentences many years later, quote, "The curves of callousness and stupidity intersect at their respective maxima," close quote. The curves of callousness and stupidity intersect at their respective maxima, says Professor Black. The assumption that separate facilities for blacks, railroad cars, steamboat berths, schools, were not inferior is a good example of the Supreme Court's formalism in that period of American law. Everyone knew the assumption was false. The Jim Crow train car was sometimes called, quote, the dirt car, and, quote, colored schools were often shacks. It was also absurd to claim that the, quote, badge of inferiority was a black person's construction. In Dred Scott, the Chief Justice, Roger Taney, had said that constitutionally black people were, quote, a subordinate and inferior class of beings, quote, with no rights which the white man was bound to respect, close quote. In Brown v. Board of Education, the Warren Court would cite psychological studies showing that black children are harmed by segregation. That's not something a 19th century court would have considered appropriate, and some people did not consider it appropriate in Brown. In cases like Plessy v. Ferguson, the court looked to the text of the statute. If the statute did not prescribe unequal conditions, then legally, conditions were not unequal. The justices in the Plessy case were aware of the repercussions that a robust interpretation of the 14th Amendment would have, of course. Political realities, as always, put a constraint on judicial reasoning. The Supreme Court in the early 20th century did decide cases in favor of African American and Asian American plaintiffs, but it mostly kept its hands off state racial regulations. When Louis Martinet formed his Citizens Committee to test the constitutionality of the separate car law, he wrote to Frederick Douglass and asked for his support. Douglass refused. He said he could not see how the case could help things. Douglass was proved correct. The decision was the worst possible outcome, and the one Plessy's lawyers had feared. It stamped a constitutional seal of approval on state-mandated racial segregation. The case may not have received much press attention at the time, but over the next 50 years it was cited in 13 Supreme Court opinions. It's true that in 1890, when the Separate Car Act was passed, Southern race relations were still somewhat in flux. Blacks voted and were politically active. The Louisiana legislature that passed the act had 16 African American members. And the composition of the Supreme Court is subject to change. The lawyers for Plessy might have hoped that they would draw a winning hand. By 1896, though, the end game was clearly in view. 6 years earlier, Mississippi had become the first state to contrive laws to disenfranchise black voters, rather than rely solely on terror and fraud. Other states followed, although extra-legal methods remained in use, and by the end of the century, the work of disenfranchisement was complete. There were 130,334 African Americans registered to vote in Louisiana in 1896. In 1904, there were 1,342. In Virginia that year, the estimated black turnout in the presidential election was 0. 1904. As for the Supreme Court, it had already made the character of its commitment to civil rights clear. In 1873, the court ruled that the 14th Amendment did not apply to most state laws, and in 1883, it struck down the anti-discrimination provisions of the Civil Rights Act of 1875, Congress's last attempt to address civil rights until 1957. Quote, "When a man has emerged from slavery," the court said, in 1883, quote, "there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws," close quote. Slavery had been abolished for just 18 years, but the court felt that that was enough time for African Americans to get on their feet. As Richard White tells us in his excellent volume on Reconstruction and the Gilded Age, published as a part of the also excellent Oxford History of the United States, between 78 and 161 black men were lynched every year in the decade from 1890 to 1899. It was the height of wishful thinking in 1896 to imagine that the court would undergo a conversion in the case of Homer Plessy. The only consolation Plessy's advocates had was that when they brought their case, there were 100 others also challenging segregation laws in the courts. If it hadn't been Plessy, it would have been someone else. Luxemburg has chosen a fresh way to tell the story of Plessy. Separate is a group biography of 3 figures in the case: Albion Tourget, one of Plessy's lawyers, Henry Billings Brown, the justice who wrote the majority opinion, and John Marshall Harlan, who filed the lone dissent. Edmund Wilson, in Patriotic Gore, published in 1962, his book on the literature of the Civil War, describes Tourget as, quote, "an obstinate man, physically and morally courageous, with bad judgment in practical matters, and possessed by an intransigent idealism," close quote. And Luxemburg's portrait is much the same. Tourget fought in the Union Army and was badly wounded. After the war, he moved with his wife and daughter to Greensboro, North Carolina, where he was active politically and as a writer and speaker on behalf of Republican policies. He called himself, quote, "a carpetbagger of the very worst sort," close quote. But by 1877, the year the Army was pulled out of the South and Reconstruction ended, he had come to believe that the whole effort was an exercise in hubris, which would be the line on Reconstruction for decades afterward, and the line taken in 2 of the most popular Hollywood movies ever made: The Birth of a Nation, 1915, and Gone with the Wind, 1939. In 1879, Tourget published a novel whose title expressed his judgment on Reconstruction, A Fool's Errand. The book was compared with Uncle Tom's Cabin and became a big bestseller. It made Tourget famous and, for a short time, wealthy. Tourget's empathy for the Southern point of view did not erode his commitment to racial justice. After leaving North Carolina, he moved to upstate New York and began writing a column under the name Bystander, advocating for racial equality. At Martinet's invitation, he served as an advisor on the Plessy case and was instrumental in devising the legal strategy. He presented the case in oral argument before the Supreme Court. Luxemburg is kinder in his treatment of that argument than other commentators have been. Instead of the standard claim that segregation was a denial of equal protection, Tourget argued that it was a denial of the 14th Amendment's guarantee of due process. "A person's reputation is property," he said, "like an inheritance. And, quote, "the most precious of all inheritance is the reputation of being white," close quote. In being denied seating in the white car, Plessy was deprived of his property without due process of law. The theory is less cockeyed than it sounds. It turns on the absence of a definition of colored in Louisiana law. Tourget was saying to the justices, Louisiana law gives state officials complete discretion in determining racial identity. Homer Plessy looks a lot like you. If someone with authority to do so classified you as non-white, would you view the situation with equanimity? No. You would think that you had been deprived of something without due process of law. This is basically the situation of Lums. This is basically the situation the Lums, Martha Lum, remember we talked about earlier, the Lums would complain of 3 decades later. In both cases, the argument was both an appeal to the racial prejudices of the justices and essentially a racist argument in itself. Whatever the calculation, it went over the heads of the court. Justice Brown, in his opinion, expressed bafflement. Plessy was colored, he said. How could he be deprived of something, quote, the reputation of being a white man, close quote, that he never had? Richard Kluger, in his landmark History of Brown v. Board of Education, Simple Justice, written in 1975, called Justice Brown, quote, one of the court's dimmer lights, close quote. And nothing Luxembourg tells us suggests that this was unfair. Brown was from Lee in western Massachusetts. He went to Yale, then pursued a legal career in Detroit. Like most Northerners, he was a Unionist, not an abolitionist, and he paid a substitute to take his place in the war rather than be drafted, as was perfectly legal. He married a woman with a large inheritance and cultivated a high style of living. He campaigned for Ulysses S. Grant in the 1868 presidential election. Grant gave him a federal judgeship in 1875, and he was appointed to the Supreme Court by Benjamin Harrison in 1890. Brown's goals in life, Luxembourg says, were, quote, ascent, dignity, money, and stature, close quote. He almost certainly saw his opinion in Plessy as a routine disposition of a familiar challenge. What gave his opinion significance was its sweeping justification for segregation laws and its timing, right at the moment that Jim Crow descended like a cage on the South. The establishment of Jim Crow was not simply a matter of laws suppressing African American voting and segregating schools and transportation, or of a pattern of social practices that became ingrained. Jim Crow was a regime that was created over and over again. In 1930, the city of Birmingham made it illegal for a black person and a white person to play dominoes or checkers together. In 1932, Atlanta prohibited amateur baseball clubs of different races from playing within 2 blocks of each other. In 1935, Oklahoma required the separation of races when fishing or boating. In 1937, Arkansas segregated its horse racing tracks. Jim Crow required a constant reminder of who was in charge. Its mania for racial separatism was insatiable. Harlan, the dissenter in Plessy, came from a family with a long history in Kentucky politics. His father was a U.S. congressman. His grandson, also John Marshall Harlan, became an associate justice on the Warren Court. Kentucky was a border state. It allowed slavery but did not secede, and Harlan began his career as a pro-slavery Unionist. He led a regiment against rebel forces in Kentucky, but he and his family had owned slaves, and he condemned the 13th Amendment as, quote, the overthrow of constitutional liberty, close quote. As Luxembourg shows us, Harlan built his reputation mainly by following the political lead of others. But after he was appointed to the Supreme Court in 1877, he became more independent. He was the only card in the judicial deck that Martinet and Tourget could count on. He had filed the sole dissent in the so-called civil rights cases in 1883. He had dissented when the court upheld the Mississippi law mandating segregated cars on interstate trains in 1890. He would later dissent, along with Oliver Wendell Holmes Jr., in the court's pro-business ruling in Lochner v. New York, 1905. Harlan's Plessy dissent seems unequivocal. Quote, in the eye of the law, he says, quote, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law, close quote. He saw as well, Douglas did, the long-term effect of the court's ruling, warning, quote, the judgment this day rendered will, in time, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case, close quote. When John F. Kennedy addressed the nation on civil rights from the Oval Office in 1963, the speech that initiated the creation of the Civil Rights Act of 1964, he quoted from Harlan's dissent. Harlan's conception of color blindness had limits, however. Quote, there is a race so different from our own that we do not permit those belonging to it to become citizens of the United States, he wrote in the dissent. Quote, persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race, close quote. It seemed to him a blatant example of how arbitrary the Louisiana separate cars statute was that it would permit, quote, a Chinaman to ride in the same passenger coach with white citizens, close quote, while forbidding African Americans to do so. This head-spinning obiter dictum about the racial status of the Chinese helps explain why Holmes once compared Harlan's mind to, quote, a powerful vise, the jaws of which couldn't be got nearer than 2 inches to each other, close quote. Separate, the book we're discussing, is deeply researched, and it wears its learning lightly. It's a storytelling kind of book, the kind of book that refers to Albion Tourget as Albion and John Harlan as John, and that paints the scene for us, quote, on a bright and beautiful night in late October 1858. Close quote. Luxemburg does not engage in psychological interpretation. He doesn't mention, for instance, that Brown's Yale classmates called him Henrietta because they thought he was effeminate, which might have contributed to Brown's eagerness not to appear like a man who didn't belong. And he dismisses in footnote speculation that Robert Harlan, a man of mixed race who grew up as a member of John Harlan's family, might have been a half-brother, even if he wasn't in fact related to John. However, it might have mattered if John believed otherwise. Luxemburg skillfully works the military and the political background into his narrative. Still, despite ample quotations from letters and diaries, the 3 principles retain a sepia quality. They seem stiff, earnest, florid, Victorian. And there is a lot of biographical backstory. It takes 400 pages to get to Homer Plessy. The argument and the decision are over after just 20 pages, and then the book abruptly ends. The afterlife of the case gets no real attention. Brown v. Board of Education receives a passing mention, a brief epilogue summarizing the post-Plessy lives of Brown, Harlan, and Tourget. And it does seem a misjudgment to tell the story of an important civil rights case as the story of 3 white men. The temptation is understandable. Tourget, Brown, and Harlan left large archives. Martinet left nothing. Even Tourget's letters to Martinet working out their legal strategy are lost. We only have copies of 4 of them that Tourget kept. Little is known about Homer Plessy outside his role as a test case plaintiff. But if we are trying to understand the Plessy case as a human story, Martinet and Plessy and millions of other African Americans are the ones who took the risks and suffered the consequences. Separate is a different way to tell the story, but it does not give us a new story. It doesn't help us with the big historical questions about the persistence of Southern racism after the Civil War. Those questions are central to a David A. Bateman, Ira Katznelson, and John S. Lipinski book, quote, Southern Nation, Congress and White Supremacy After Reconstruction. A fine-grained and valuable scholarly analysis. Okay, that's the book title, Southern Nation, Congress and White Supremacy After Reconstruction by Bateman, Katznelson, and Lipinski. The authors argue that, quote, rendering the South as peripheral to the history of the United States minimizes the extent to which the South was co-creator of the nation's history, and obscures the ways in which the ideas and practices underpinning this racial order were projected across the United States, close quote. As many historians have pointed out, one of the reasons the South was able to exercise a stranglehold on race relations in national politics was the supervention of famous 3/5 clause, once the focus of abolitionist attacks on the Constitution. When the former slaves were counted as full persons, the former slave states gained 20 congressional seats, a 25% bump. They also gained votes in the Electoral College. They suppressed the votes of their African American residents, then got full representational credit for them. But where was the political will in the rest of the country? Separation of the races did not originate in the slave South. The nature of the institution made that impractical, if not impossible. As Luxemburg says, repeating one of the main points of C. Van Woodward's classic study, quote, The Strange Career of Jim Crow, published in 1955, segregation began in the North, where it was the product not of the practice of slavery, but of negrophobia. In 1835, Alexis de Tocqueville wrote, quote, The prejudice of race appears to be stronger in the states that have abolished slavery than in those where it still exists. And nowhere is it so intolerant as in those states where servitude has never been known. Close quote. This helps explain why the majority opinion in Plessy was by a man from Massachusetts who had no experience with slavery, and the dissenter was a man from a slave state who had once owned slaves himself. After 1900, the South had Jim Crow, a legal regime of separatism, but the rest of the country had ghettos, redlining, gerrymandering, quota and exclusion systems, and the artifice of the local school district. De facto discrimination, we now call it, quote, institutional racism, or, quote, structural racism, is much harder to address. It requires more of people than just striking down a law. Excellent piece. Thank you for staying with me. If you did, thank you, Louis Menand, for an excellent piece. Okay, bye.